Namaskar. I'm Assistant Professor Kritika Dev from LG School of Law. And today, before moving on to the topic, I hope you must have seen my first lecture of documentary evidence. That was part one, and this is part two about documentary evidence. So let's go in detail and study what was not there in the first session. Let's continue with it. Before moving on with section 64, let's see what we had seen in the previous lecture. We had seen that contents of the evidence can be proved by the primary evidence or the secondary evidence, right? Under which we had seen what will be considered as an primary evidence and what will be considered as an secondary evidence. Now, section 64 here says proof of documents by primary evidence. Now, this section simply states that documents must be proved by primary evidence. Now, first preference should always be given to the primary evidence. When it comes to proving of a document, it should be through the primary evidence. But except in the cases hereinafter mentioned under section 65, as you can see on your screen. So, if there is any of the situations which are mentioned under section 65, then you can give the secondary evidence of the same. Other than those situations, you cannot. So if your situation falls under any of the situation which is mentioned under section 65, then you can produce the secondary evidence in order to prove your document. Otherwise, you just need to prove your, you just need to bring the primary evidence in order to prove the facts. So here, 65, as I said, it mentions the scenarios in which you can produce the secondary evidence, cases in which secondary evidence relating to documents may be given. Now, the first one is when the original is in the possession of the adversary, right? Now, the very first point is when the original, and of course, you need to prove it in front of the Honorable Court that it lies in the possession of the other party who's against you, who's the adverse party. Party who's litigating against you, the document is in his possession, then of course, how can you get that? Then you ask for the permission from the Honorable Court whether can you prove the secondary evidence by stating this very reason. And of course, if you state it and everything is in proper shape, then the court would allow you to give the secondary evidence because the original is in the possession of the adverse party, right? The next one, when existence, condition, or contents of the original have been admitted in writing. Now, it talks about the writing. Now, if there is any existent condition or contents of the original, it have been admitted in writing by the other party before the hearing. Before the hearing, the other party admitted the contents in writing. Now, it has to be in writing, and that writing, the paper on which that written statement was there, that writing was there of the adverse party, should be produced before the Honorable Court, not any other document. So, when it comes to content, if you do not have the original, but you have something written which talks about the contents or the condition or the existence of the original document given by the adverse party itself, and it has to be in writing and before the hearing, then you can produce that very document before the Honorable Court, and that will be taken as the secondary evidence of the original one, the document of about which the adverse party is writing. Right? Because of course, if the adverse party is writing about a document which you are supposed to prove, then it will go against the other party. And if you prove the same document which was actually written by the adverse party, it will support your case. Then that very written paper or written document will be taken as the secondary evidence. The next one is when the original had been destroyed or lost or cannot be produced. Now, if the original had been destroyed or lost, now that you'll have to prove before the Honorable Court how it got destroyed or how it got lost. For say, you just tell it to the court or you submit in front of the Honorable Court that your house was on fire, right? Every document got burnt, my lord. So I just have the copy of it. I cannot produce the original. So I just have the copy of it, which was there in one of my lockers or wheresoever. So a basic example, a basic thing which could be on it, or basic fact which could be stated and through which the secondary evidence would be admissible. The next one is when the original is not easily movable, right? For say, if something is of such a nature, for say when it comes to documentary evidence, anything written on the pillars also will be taken as the documentary evidence, right? Now you cannot move that pillar, or when it comes to the monument, something is written there, you cannot bring that up. So here it is not movable, you cannot move that very thing. So you will submit the copy of it. You will click pictures, or you will take anything, and then you will submit the copy of it, and the court will admit it because the original document was not movable. So anything even written on the monuments, on the walls, the ancient ones, and if it is anything related to it, it is dispute and that thing cannot be moved, then you can submit the secondary evidence. Now, when the original is a public document. Now, of course, when it comes to the public document, you will not get the original document, right? You will just get the certified copy of it. So, whenever it comes to the public document, of course, the government is not going to hand over the main document to you. You can just get the certified copy of it. So, when it comes to the public document, a certified copy of the same shall be accepted as the secondary evidence. Now, the next one is when the original is a document of which certified copies is permitted by law to be given in evidence, right? So, it is directly a rule of evidence which is directly stated that the certified copies of these documents will be accepted. So, the certified copy here under this case will be accepted as the secondary evidence because it is directly been given by the law, right? Now, when the original consists of numerous accounts or other documents. Now, when the original has number of accounts, number of copies, number of documents, right? Then what will happen in that case? If the document has number of copies, number of accounts, so there are numerous accounts. Then what will happen in this case? Of course, in order to save the time of the court, for say when it comes to a big account book, the number of sheets, number of balance sheet, number of numbers, the court will consume, the time of court will be consumed. So here an overall result of those number of accounts can be submitted, and that overall result will be taken as the secondary evidence here, right? So here it is all about the secondary evidence and under what circumstances secondary evidence will be accepted. So if your condition falls under any of these conditions, only then you will be allowed to give the secondary evidence. Otherwise, you will not be allowed to give the secondary evidence. Now, there had been an amendment, that is section 65A and 65B under the Information Technology Act 2000. So, with the amendment, section 65A states the contents of the electronic records may be proved in accordance with section 65B, right? So, when it comes to the contents of the electronic records, then it could be proved according to section 65B. 65B talks about the admissibility of the electronic evidence, right? So, it is about 65A and 65B. So I hope with this you are completely clear with the as you can see on your screen, the conditions which are being mentioned, easy to understand. And in general, the general rule is that only primary evidence should be given when it comes to the documents. Let's go for a quick revision. As I was saying, when it comes to the documents, only primary evidence should be given. But if your condition falls under section 65, any of the conditions which are mentioned under section 65, then you can give or you can present the secondary evidence. Otherwise, you will have to prove your case according to section 64, and that is through the primary evidence, that is the document itself. Primary evidence means the document itself. Otherwise, the secondary evidence will be permissible according to section 65 of the Indian Evidence Act, right? With this, I hope everything related to it is clear. We have seen all the contents, all the ingredients of the sections. And with this, again, I would like to tell you, keep revising. Otherwise, it is very difficult to have everything related to evidence in mind. So after the lecture, keep revising and keep studying. And till then, take care. And thank you so much for for being so, so, so such a nice audience and listening to me. Thank you so much.